My name is Shamina Hamiza binti Zulkifli, counsel for the appellant, Mr. Dangal.
My name is Nur Hazifa binti Nur Hazam, and I am the co-counsel.
This is a case about a contract between the parties where the respondent Naina ordered to buy 12 sets of winter clothing from my client with the total price of 1,000 ringgit, the appellant, Mr. Dangal. Defendant only paid 500 ringgit and she promised to pay the balance when she gets the payment for her part-time job on 30 July 2020. Plaintiff agreed with defendant to pay the balance later, but defendant refused to pay the balance payment of 500 ringgit to plaintiff. And she said she is only a minor and she does not have to pay anything to plaintiff.
May it please the court, my name is Nur Shafiza binti Kasmui, counsel for the respondent Naina.
My name is Muhammad Shazwan Bisharif and I am a co-counsel.
Your Honor, ladies and gentlemen of the jury, this is a case about contract between Naina as a defendant and Mr. Dangal as a plaintiff, where the plaintiff is willing to accept defendant offer without any condition.
The issue in this case is whether the contract between plaintiff and defendant is valid, void or voidable because defendant ordered 12 sets of winter clothing from plaintiff and the total price is 1,000 ringgit. Defendant only paid 500 ringgit and refused to pay the balance 500 ringgit to plaintiff. Defendant says she is only a minor and she does not have to pay anything to plaintiff. Answer issue. Based on the issue, the contract between plaintiff and defendant is valid even though defendant is a minor. This is because plaintiff can claim under the exceptions of a contract with a minor which is under a reimbursement for necessary of the minor. This is because defendant ordered 12 sets of winter clothing from Winter Tailor with plaintiff for 1,000 ringgit. However, she only paid 500 ringgit and promised to pay the balance when she gets the payment for her part-time job on 30 July 2020. Defendant has to pay back the money to plaintiff because defendant ordered the winter clothing for her condition in life, which she wants to use during the winter season for study. Definition. Necessary can be defined as goods, service, or expenses that are considered necessary, such as goods, service, or expenses as are essential to the maintenance and support of a present or former spouse or of the child of divorced parents, and for which one spouse or parents may seek reimbursements or contribution from the other. In our case, the winter clothing that defendant ordered is considered necessary and suitable to the condition in life of defendant to use in the winter season for study. Plaintiff may seek reimbursement or contribution from the defendant to pay back the balance money. Your Honor, please refer to Section 69 of the Contract Act 1950 states that if a person incapable of entering into a contract or anyone who is legally bound to support is supplied by another person with necessary suit to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such an incapable person. Related to our case, based on Section 69 of the Contracts Act 1950, defendant contracts between plaintiff with necessary suit to defendant condition in life, which is defendant use the winter clothing during the winter season for study. Plaintiffs who has furnished such supplies is entitled to be reimbursed from defendant of such an incapable person. Your Honor, please refer to the principles that were declared in the case of Nash v. Inman. Facts. Nash, a tailor on Seville Road, entered into a contract to supply Inman, a comrade and a graded student, with amongst other things, 11 fancy waistcoats. Inman was a minor who was already adequately supplied with clothes by his father. Hence, the tailor failed in his action because he had not established that the clothes were suitable to the condition in life of the minor, and in this case, the student was already adequately supplied with clothes. Thus, whatever goods supplies to the minor must be supplied to his actual requirements and conditions of the life of the minor and the need at the time it was delivered. Relating to our case, plaintiff can claim defendant to pay back the money because the winter cloth that defendant buy is necessary for the minor, and she used in the winter season for study. Plaintiff can claim the minor which is defendant to pay the balance payment. Based on the judgments of the case Nash v. Inman, the court declared that defendant should pay the balance to plaintiff.
Your Honor, ladies and gentlemen, the issue in this case is whether the contract between Mr. Dangal and Naina is valid, void or voidable, because Naina ordered 12 set of winter clothing from Mr. Dangal and the total price is 1,000. Naina only paid 500 and refused to pay the balance to Mr. Dangal. Naina said he is only minor and she does not have to pay anything to Mr. Dangal. Your Honor, I would like to direct your attention to the real issue in this case, which the contract between Naina and Mr. Dangal is void because Naina is only minor and she does not have to pay anything to Mr. Dangal. This is because Naina is 16 years old, which is under age of majority 18. Thus, the contract is void and Naina has to return the winter clothing to Mr. Dangal. Your Honor, I wish to rebut the point made by plaintiff because in this case, the necessary is irrelevant because Naina is a minor. We can refer to definition of minor is all state defined and age of majority, usually 18. Persons younger than this age are considered minor and must be under the care of the parents, guardian unless they are incapacitated. General rule in Malaysia, all contract entered into by minor are void and that minor cannot be sued or sue in a contract. Relating to the case, all state define an age of majority, usually 18. Naina who are younger than this age, which is 16 years old, considered minor and must be under the care of the parents, guardian unless they are incapacitated. General rule in Malaysia is contract Naina with Mr. Dangal are void because entered into by minor and that minor cannot be sued or sue in a contract. Your Honor, I wish to rebut the provision made by the plaintiff because the proper provision is to be referred to Section 2. Please refer to Section 2 of Majority Act 1971, which is subject to Section 4. The minority of female and male shall case and determine within Malaysia at the age of 18 years old and every male and female attaining that age shall be the age of majority. According to Section 2 of Majority Act 1971, subject to Section 4, the minority of Naina shall case and determine within Malaysia at the age of 18 years old, but Naina is only 16 years old and not attaining that age shall be the age of majority. Related to our case, Naina is a minor who is 16 years old and she wanted to pursue her study at the University Leeds in West Yorkshire, England. Since her class start in winter season, she buy the winter clothing from a winter tailor named Mr. Dangal. Then she refused to pay the balance. Your Honor, the principle of a decide court case that support my argument is case of Mohari Bibi versus Damodas Gossi, which state the fact that Mohari Bibi versus Damodas Gossi is a case that cover the ambit of minor agreement. The case basically deal with a minor contract or a contract with a minor. In India, an agreement or a contract with a minor, a person who is below the age of 18 years old or any person who has not completed 18 years old of age legally, is void, which is void from very beginning. Such rule regulation are made because according to law, such people does not come under the ambit of capacity of contract or agreement of doing so. The health is applying and in fact cannot make any valid contract of loan, sell house. Relating to the case, Naina refused to pay the balance payment of winter clothing because she is minor and does not have to pay. Based on the judgment of Mohari Bibi versus Damodas Gossi case, the court should decide that Naina cannot make any valid contract with Mr. Dangal.
So the court give me 1 minute. I want to give you my rebuttal. My agreement is based on why the defendant did not want to pay the remaining balance RM500 to the plaintiff when plaintiff had said defendant ordered 12 set of winter clothing, fabric, demand necessary and fit the condition in the defendant life to use it for study. Although the defendant is minor, the defendant must pay the balance RM500 to the plaintiff because winter clothing is a necessity for defendant to use it in the study during winter season.
Your Honor, I disagree. The agreement given by the counsel of the plaintiff said that the defendant have to pay 500 ringgit balance. This is because based on the Section 10, all agreements are contracts if they are made by the free consent of party competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Other than that, in Section 2 of the Age of Majority Act 1971, enact that the minority of all male and female shall cease and determine within Malaysia at the age of 18 years, and that every such male and female attaining that age shall be of the age of majority. According to the case Tan Hee Juan versus Teh Bon or Mohori Bibi versus Domodes Gossi, beside having statute to prevent from the defendant held liable, me and my counsel want to enlighten and strengthen my argument by referring to the case of which the case was held similarly with two other cases that have given a full recognition of Section 10 and Section 2.
To conclude my case, based on the issue, the contract between plaintiff and defendant is valid even though defendant is a minor. This is because plaintiff can claim under the exception of a contract with a minor which is under a reimbursement for a necessaries of the minor. This is because defendant ordered 12 set of winter clothing from Winter Tailor with plaintiff for RM 1000. However, she only paid RM 500 and promised to pay the balance when she get the payment for her part-time job on 30 July 2020. Defendant has to pay back the money to plaintiff because defendant ordered the winter clothing for her condition in life which she wants to use during the winter season for study. In our case, the winter clothing that defendant ordered is considered necessary and suitable to the condition in life of defendant to use it in the winter season for study. Plaintiff may seek reimbursement or contribution from the defendant to pay back the balance money. Related to our case, based on Section 69 of the Contract Act 1950, defendant contract between plaintiff with necessary suited to defendant condition in life, which is defendant use the winter clothing during the winter season for study. Plaintiff who has furnished such suppliers is entitled to be reimbursement from defendant of such an incapable person. Relating to our case, plaintiff can claim defendant to pay back the money. Because the winter clothes that defendant buys is necessary for the minor and she used in the winter season for study. Plaintiff can claim the minor which is defendant to pay the balance payment. Based on the judgment of the case Nash v. Inman 1908 to KB1, the court decided that defendant should pay back the balance to plaintiff. For the foregoing reason, I respectfully request that the court find in favor of the appellant and allow my clients to claim to pay back the money for breach of contract as provided under Section 69 of the Contract Act 1950.
To conclude my case, the contract between Naina and Mr. Dangal is a void because Naina is only a minor and she does not have to pay anything to Mr. Dangal. This is because Naina is 16 years old, which is under the age of majority 18. Thus, the contract is a void and Naina has to return the winter clothing to Mr. Dangal. Relating to the case, all states define an age of majority, usually 18. Naina, who are younger than this age, which is 60 years old, are considered minors and must be under the care of the parent or guardian unless they are emancipated. General rules in Malaysia is a contract Naina with Mr. Dangal are void because entered into by minors and that's a minor cannot be sued or be sued in contract. According to Section 2 of the Majority Act 1971, Act 21, subject to Section 4, the minority of Naina shall case and determine within Malaysia at the age of 18 years old, but Naina is 16 years old. And Naina not attaining that age shall be of the age of majority. Relate to our case, Naina is a minor who is 60 years old and she wants to pursue her study at the University of Leeds in West Yorkshire, England. Since her class start in the winter season, she buy winter clothing from a winter tailor named Mr. Dangal. Then she refused to pay the balance. Relating to the case, Naina refused to pay the balance payment of winter clothing because she is a minor and does not have to pay. Based on the judgment of Mahori Bibi v. Domodes Gossi case, the court should decide that Naina cannot make any valid contract with a Mr. Dangal for the foregoing reason. I respectfully request that the court find in favor of the respondent and dismiss the appeal made by the appellant.